I'd like to welcome everyone here today for this training. We're going to be discussing transition to adulthood, and we're going to cover in particular key areas for long-range planning. My name is Rebecca, and I'm a parent consultant and a trainer for the Utah Parent Center. And it is important to my husband and I, it is our desire to make sure our daughter's long-range planning needs are taken care of so that she will have a successful and a happy future in her life. So for this training, we're going to be discussing planning for changing health care needs. We're also going to be covering living arrangements, estate planning and financial issues, and we will touch on guardianship as well. So let's go ahead and start with health care issues. There was a survey done of 1,300 youth with special health care needs and/or disabilities, and their main concerns for health were what to do in case of an emergency. Many of them did not know how to get their health insurance. Many didn't know what could happen if their condition got worse, and also just learning how to stay healthy. They didn't have much education in this area. So what we can learn from this survey is that many youth with special health care needs and/or disabilities aren't prepared to independently take care of their own medical and health needs. Many are unfamiliar with how the healthcare system works. So as parents, there are some things that we can do to help turn that outcome around. For one thing, we can educate them earlier in the process and teach them how to become self-advocates so that they will have confidence in their abilities to manage their health care needs as they arise. We can continue to encourage independence by working on their self-help skills. We can also teach our teens to talk with their own physicians, especially about age-appropriate information such as their emotional and their physical well-being. I do have a story to share of a friend who works for another adult care agency, and she's also a friend of our agency, and she shares this story with people of when she was younger and she would go with her mom to her doctor's appointments. She herself has a physical disability, and while she was in her appointments, her mom and the doctor would talk back and forth with her in the room, but really not including her in the conversations about her health. Well, as she became an adult, she decided she was going to become her own self-advocate, and she wanted to go to her doctor's appointment by herself, which she did, and her mother, took that step back. But it was interesting. She relates the story that when she went into the doctor's office, the doctor looked at her with this perplexed look on his face and wanted to know where her mother was. So it was clear to her that this doctor didn't respect her self-advocacy as an individual, and needless to say, she did try to find another doctor for herself. But this story does illustrate the fact that as parents, we do need to take that step back, and we need to let our young adults take part and to talk to their doctors one-on-one and to learn that self-advocacy for themselves. Now, another thing that we can do for our young adults with disabilities who are able, we can teach them to make their own doctor's appointments. If they're able to order their own prescriptions, let's let them go ahead and do that. Many of them may need medical supplies for their disability or special health care needs. Allow them to go ahead and order those supplies. An activity that you might want to consider in working with your child would be to sit down with them and help them to write an up-to-date medical history. And think about how much they could learn from that activity of you and them sitting down together and doing that. Lastly, one pointer I'd like to leave with you would be to check with your current insurance plan about changes in health care coverage. On many insurance policies, a young adult may age out of their parents' policy when they reach a certain age. So if this is the case with your health insurance policy, you will want to contact them and find out what your options are. In some cases, a family may find it necessary to consider Medicaid for their young adult because they will no longer meet the age criteria or the dependent criteria of their private insurance. And it is important to note that When your young adult reaches 18, it will be easier for them to qualify for Medicaid because they no longer look at the family income. Another survey was done about healthcare-related outcome realities, and it was found in this survey that nearly 40% of young adults with special healthcare needs and/or disabilities could not identify a primary care physician. 20% considered their pediatric specialist to be their regular physician. Primary health concerns were not being met, and it was noted in the survey that parents did have a hard time giving up the decision-making role. So one of the things that we can learn from this survey is that transitioning to adult health care can sometimes be difficult. And as youth with disabilities, as they become adults, they are going to have to transition from pediatric health care to adult medical care. Finding a new medical care doctor can be overwhelming, especially when they've developed that long-term relationship with the pediatric specialist. But it's important, even though it does take some time to find the right fit, that they go through this process, and you as parents can be supportive in helping them find, a new adult medical care doctor. Because all adults with special health care needs, they deserve to have that adult-focused primary care physician. Let's go ahead and talk about different types of living arrangements. Young adults with disabilities, they do vary in their ability to be independent. And it is helpful to know what the living options are in your individual communities. This way, you and your young adult can find the option that best meets your needs. If you have a child that is in need of a state-supported living arrangement following their high school, I would recommend that you contact the Division of Services for People with Disabilities, and I would make this contact early because of their wait list. It can be 3 to 6 years or even longer, and this would be for a wait list for many of their community residential service programs. So let's talk about some different types of living arrangements and environments that could be available in your communities. We will talk about living with the family. We'll also talk about living independently, supervised living, residential care, the professional parent or host home, as well as intermediate care. So we're going to begin with living with the family. Many families believe that living with the family is a good option, especially if they have a young adult with a disability, and those disabilities are very significant. My grandmother had a child with several severe disabilities, and this was her preferred option because she wanted to maintain control over the quality of care her daughter had. But in contrast, there are families who may not want their young adult to live with them forever. They think of it as more as a temporary option. So you'll have to decide amongst your family and values, and as you talk with your young adult with the disability, you'll want to incorporate their interests into their planning. But young adults who do live with their family, they should be encouraged to develop and improve their independent living skills while at home. So you can give them jobs such as housekeeping, shopping, washing clothes, and even budgeting. And it is important to note that families may not always be able to physically care for their child with a disability, or their child may outlive them. So it is important to plan for the future and to think about additional types of living arrangements that you may need to consider. Living independently is another option. When young adults live independently, they either live by themselves or they live with a roommate. This can be done in a home or an apartment, for example. And in this living arrangement, little or no help is needed. If help is needed on occasion, then it would be done by a family member or an adult service provider, and it would be through visits or through telephone contacts. Let's talk about supervised living arrangements. Some young adults do need more support or supervision. And so supervised living, such as a supervised apartment, offers more structured living for these individuals. So young adults would receive assistance and training in independent living skills, such as meal planning and money management, and the supervision is usually provided by personnel from an adult service agency or provider who are trained in working with young adults with disabilities. Another option to consider would be a residential care facilities, and these would include group homes that offer help to young adults who cannot live independently, but they are able to spend time in the communities with little amount of supervision. So community resources are used in this type of an environment for recreation, medical, or social services, and the group home staff are employed by a local adult service agency, and they're trained to work with young adults and develop their independent living skills. There's also the option to consider of a professional parent or a host home. And this is an environment where a young adult who is unable to live independently lives with a host family or in a private residence. The family provides room and board, and they also provide opportunities for social education and recreational activities. And then lastly, the intermediate care facility is a facility that provides 24-hour care for individuals who, through illness or disability, require an ongoing nursing or medical services. And these medical services must be provided by a registered or a licensed practical nurse or a doctor. Okay, we're going to go ahead and move on to the important issue of estate planning. And there are some things you need to consider as you go through this process. Many parents feel that leaving an outright inheritance for their son or daughter with a disability is the best way to care for their needs after they pass away. If your child is going to solely rely on that inheritance and has no need for any public program benefits such as Social Security or Medicaid, this may be a good option. However, most parents I talk to are planning on needing the assistance that comes from benefit programs. And these benefit programs such as Medicaid and Social Security, they do have eligibility requirements. So therefore, someone who is on an assistance program and they receive an outright inheritance means that the public assistance money would stop, while the inheritance money would be used to pay for those needed services, such as, for instance, medical care, a group home, or even a day activity program. Only when that inheritance money is gone does the public money become available again. So this is something that's very important when you consider doing estate planning for a child that has a disability. Okay, we're going to go over some guidelines to consider when you do your estate planning. First of all, we will talk about 7 planning questions that are unique to families that have a member with a disability. We will also consider the reasons why a team of qualified professionals are important. We will discuss things to consider when you develop your necessary legal documents, and we will also talk about the funding for a trust. Let's begin with the 7 planning questions. And again, these questions are unique to families with members they have members with a disability. So the first planning question to consider, and think of these answers to yourself: who will care for your spouse or child with a disability if I am physically unable to do so? The second question: how can we maximize government benefit programs that currently assist families of people with disabilities? Question number 3, how can we coordinate our personal resources with government benefit programs to provide the best possible lifestyle for the individual with a disability both now and in the future? How can we provide sufficient resources to ensure a comfortable lifestyle without the government having claim on the inheritance? How can we manage our resources so that they are available for the life of a person with a disability? How can we ensure a dignified funeral and a burial service when your son or daughter dies? And how can we get the rest of the family to understand and support the plans that we make? To answer these questions, it does take a lot of thought and planning, and it would be wise to consult professionals on many of these types of questions. It is recommended that you seek a team of qualified professionals experienced in these matters. So this would mean more than finding an attorney. You would also want to consider seeking an accountant, a financial planning professional, as well as an advocate, and together the team can develop and implement estate needs that will suit your family. So how do you find these professionals? There's some different things that you need to consider. I would start by asking others in similar circumstances who they have used. Did they like someone? They felt like someone did a good job. Find out who they are. Make sure when you start calling around to different professionals that you know that they are familiar with estate planning for families with a member that has a member with a disability. You can contact a disability agency such as the Utah Parent Center. I would also recommend that you ask the professionals that you talk with if they already have colleagues whom they work together with as a team, so that your family can get the maximum benefit for the least amount of cost. And also remember to ask for references from the individuals you're considering working with, just to make sure that you feel comfortable with them, you know that they're competent in what they're going to be doing, because this is a very important issue. Now let's talk about some legal documents. Once you have a team of qualified professionals in place working on your behalf, they can help you provide these different types of documents. The first one I want to talk to you about would be the letter of intent. This is an in-depth letter that is actually written by a parent that is regarding the child with a disability. And the letter would include that child's likes, dislikes. It could also include special communications, medical information, housing preferences, and needs as well. So this information would be important for a future trustee. It would also be important for someone who may be the child's future guardian. Another thing to consider having done and would be recommended is a complete analysis of your resources. This would be both family resources and also individual resources. Remember to cover government programs as well as private resources, and you will need a plan to maximize these resources. You will also need paperwork to ensure the appropriate execution of all your legal documents. So this would include the appointing of a trustee as well as a successor trustee. I want to talk to you a little bit about assets, and there are two categories of assets that should be taken into account when you do your estate planning. The first category would be those assets listed in your will. These would be assets subject to probate. And then there would also be assets not subject to probate, which would include life insurance or the proceeds from an individual retirement account. In both cases, it would be important not to name the person with a disability as either an outright heir or a beneficiary. So it may be helpful to discuss these potential inheritances with your grandparents or other relatives. Relatives may have good intentions, but they don't necessarily understand the requirements of the benefit programs that your child may be dependent on. So there are three ways of preventing a person with a disability as being named as an outright heir or a beneficiary. The first way would be to omit the person from your will. The second way would be to make a gift to an individual other than the person who has the disability with an unofficial understanding that the proceeds would be used for the person with the disability. Now you need to remember that this cannot be an official written document. If it were, then that gift would be considered an asset of the person with a disability and jeopardize his or her public assistance. So this would be considered an informal type of an agreement, which makes it a risky one, since there is no guarantee that the gift in question would be used as the parents intend. So there is one other option to consider. This would be to establish a trust, and many parents seek out what's called a special needs trust. And a trust is good. It does ensure that an estate's proceeds or a portion of the proceeds are used to benefit the son or daughter with a disability. And the idea would be to enrich their lives without jeopardizing their public assistance benefits. Okay, we're going to discuss funding for a trust. A trust is a very complicated document, and it has to be drafted very carefully. Trust funds, if and when they are spent, they have to be used for the benefit of the person who is the trust beneficiary. So in our case, that would be the son or daughter with the disability. Yet in order for the trust funds not to jeopardize their eligibility for public assistance programs such as Medicaid and Social Security, the trust fund's assets cannot be considered his or her assets. So, to prevent the loss of these programs, the trust funds are considered the designated trustee's assets. And the trustee is legally granted sole discretion on how the funds are to be spent on behalf of the beneficiary. So when developed very carefully, these trust funds can add to the quality of their child's lives even after the parents pass away. Okay, let's move on to guardianship. And this is important to understand for parents. When your young adult turns 18 years of age, he or she becomes an adult. And the law doesn't differentiate between who has a disability and who does not. So once an adult, he or she automatically receives certain civil and legal rights. If your young adult has significant disabilities and is unable to provide for their basic necessities of life, such as food, shelter, clothing, and medical care, you may want to consider looking into guardianship. Now, I want to go over with you what the definition of guardianship is. Guardianship is a legally authorized relationship between a competent adult, who would be the guardian, and an adult with a disability. And in this relationship, the guardian is given the duty and right to act on behalf of the person with a disability in making certain decisions that affect his or her life. When a guardian is appointed, the court gives the guardian the authority to exercise rights and correspondingly takes those rights away from the person with a disability. So for this reason, guardianship is considered restrictive and should only be used when necessary. Now, guardianship may be considered for adults with disabilities who are 18 years of age or older, and by reason of either a judge or a jury are found to be incapacitated. An incapacitated person might be any person whose decision-making process is impaired. Now, it could be impaired by a mental deficiency. It could include a physical illness or a disability. It could be due to chronic use of drugs, chronic intoxication, unusually bad judgment, a highly impaired memory, or a severe loss of behavior control. But regardless of the individual's disability, it's important to remember that a parent is not automatically the guardian of a son or daughter when they reach the age of 18 years of age. If a parent wishes to become a guardian, then only a court order can make a child a ward and appoint a guardian. Now, when the court appoints a guardian, the powers and the duties of the guardian must be specified, but they could include things like the authority to determine the ward's residence, their care, and also their employment. It could also include the responsibility to make sure that their basic needs are met, their food, shelter, their clothing, and their medical needs. Authority would also include the ability to make decisions on behalf of the ward, such as whether or not to marry. And it also includes the responsibility to keep the ward's financial affairs in order. Okay, for more information on this, you can contact the Utah Parent Center, but we also recommend to many parents that they contact Guardianship Associates of Utah, and they have a lot of good information in regards to guardianship as well. Okay, this concludes my training on long-term planning issues. I know this is a lot of information, and if you have questions about any of the areas that we've discussed today, I would recommend that you contact the Utah Parent Center. You can ask for a parent consultant, and we're happy to talk to you about your issues and send you information that can be helpful for you as well. And thank you very much for being here.